Bruno, this question is for you. She says, good morning. Can an agent evict me for non-payment of 1 month in a years-long lease? She says she's on the 9th year now. Well, sorry, it's the 9th. I'm assuming that's the date that she asked. Yeah. The 9th day, I'm assuming. So potentially, payment was meant to be made on the 1st. And I think when she asked the question, it may have been the 9th of the month. Sure. She was informed by the agent that they were going to advertise the property from the 1st of June. And if the agent doesn't find tenants, that Laurent, in this particular case, would be responsible for payment. Bruno, maybe there's a bit to unpack here, but what advice can you give Laurent?
So maybe let's start having a general conversation, and then we can start trying to apply the facts to it. So you've given the facts. So now, in general, what one looks at when dealing with lease agreements is certain concepts here about fixed-term lease agreements that last for a fixed period of time. When one is able to terminate these long-term lease agreements, under what circumstances would the landlord be entitled to terminate? And what impact a breach has on these lease agreements. So remember, a lease agreement in general is binding between the parties. There are certain exceptions where a party can exit early. So a tenant, for example, in terms of the CPA, is entitled to exit early, but there's a whole bunch of rules behind it in terms of Section 14. A landlord, under certain circumstances, can cancel a lease agreement if circumstances arise. Again, this is all governed. But in general, if you sign for 12 months, you stay for 12 months. That's the rule. So breach comes in, and all that breach and repudiation means is somebody did something contrary to the terms of the lease agreement. And whatever they did contrary to the terms of the lease agreement is material enough to justify the cancellation of the lease agreement. So materiality depends. There's a number of different scenarios or circumstances one can look at to determine whether it's material or not. But for our current purposes, we're looking at non-payment of rent and whether that's a material term of the lease agreement or not. Now, obviously it is. And I mean, I think this is, it goes beyond any level of dispute or debate. It's the most material term of the lease agreement, being the payment of rent. So now we've determined that non-payment equals breach of the agreement, and more likely the lease agreements in general provide for the cancellation on a breach, given some form of notice. The CPA, as an example, provides for cancellation of lease agreement upon 21 business days notice. So now it's a given that, provided that that notice has been sent, that within those 21 day period, the breach hasn't been rectified, namely the rent hasn't been paid, and the landlord cancelled the lease agreement, then there is no lease. And if there is no lease in those circumstances, to answer the question, yes, the landlord will be entitled to evict you because the lease has been cancelled. They have to follow due process, however. So it's not simply a question of locking the door and off you go, but they would have an entitlement to evict you. Unfortunately, this is where the facts start becoming a bit again speculative. So Lorraine said that she's on the 9th now. Now I'm making certain assumptions, but if your rent is due on the 1st and you're on the 9th, you haven't paid, agent comes to you and says, you know what, I'm advertising again and I'm going to find you tenants. But if you don't, you're responsible for payment. This is a bit confusing for me, because in my mind, you are responsible for payment in any event, because the lease is still in place. If you're only on the 9th, 21 business days has not lapsed, which means that you're still within a suitable time period to rectify your breach, if your issue is that you don't want to move out the property. If you mean 9th month, so you're in the 9th month of the lease, can the lease be cancelled? Yes, it can. If you're in breach, 21 business days notice has been given, you failed to pay the rent, and it's the 9 months, doesn't matter. They can cancel the lease. Start looking for new tenants. Are you responsible for payment if they don't find new tenants? the short answer, without getting legally technical, is you're responsible for payment as long as you're staying on that property. Because at the end of the day, whether it's under a lease or whether it's a terminated lease, you're enjoying occupation of the property. So in our law, there's two different claims that a landlord can submit for that amount. But in the tenant's eyes, it's inconsequential. The reality is, it's basically the equivalent, the consideration for staying on a property that belongs to the landlord and for enjoying its use.
Thank you, Bruno.